Hey guys, David here. Welcome to Digital Outlook, where you're gonna find the best community in all of crypto. In today's video, we're gonna talk about why the SEC's chances of winning this case are absolutely doomed. So guys, without further ado, why don't we get to it? So guys, right at the top, would you smash that like button down there so the algorithm will push this information out to as many people as absolutely possible? That would be fantastic. Now, guys, one thing we all know, we have probably heard every kind of opinion and suggestion with respect to how this Ripple versus the SEC lawsuit is going to play out. I mean, we have heard about all kinds of settlement dates. We've heard about summary judgment and what people think is going to happen in that case. And we have also heard that this whole thing could be dragged out either way that it's decided all the way to the Supreme Court. Now, guys, that may be a real possibility due to the fact of the impact that this case is going to have going forward for our entire economy. Guys, this is going to be a case that's so pivotal. It's going to be like what the Howey test was way back in the 1940s, and it is still having an impact today in the 2020s. We are moving into a brand new digital economy, and you can bet your bottom dollar that all of these digital assets that are going to move forward into that digital economy are going to be governed by regulation. And we need some level of legal precedent to know what kind of clarity and regulation will that look like. And I believe personally that this Ripple versus the SEC case is going to set the standard for decades to come when we're talking about that kind of clarity. Now, just recently, an article was pumped out, and this is in respect to John Deaton's view of the SEC's chances of really winning this case. Now, guys, I want you to take a look right here at this article and just take a look at this title. XRP lawsuit. Why the SEC's winning chances against Ripple are doomed. Now, this is coming from John Deaton, and of course, they're designating him as XRP holders' lawyers because he's actually representing 75,000 XRP holders in this particular case. And Deaton is claiming that the common enterprise allegation has become a real problem for the SEC in the case. So here we have the beginning of the article. The U.S. Securities and Exchange Commission have tried to stand its ground by presenting a different assertion against Ripple and the defendants in the XRP lawsuit. However, the claims around the common enterprise have become a real problem for the SEC. Now, John Deaton called out the experts which are predicting that the SEC will secure a win here and claim that the XRP is now doomed. He asserted that they are overstating the commission's chances as their allegations stretch too far. Now, Deaton pointed out here the SEC's argument around Ripple, stating it is a common enterprise. However, Ripple has already forced the commission to admit that holding XRP doesn't give a holder rights in Ripple. Guys, there was no contract or agreement between XRP holders and Ripple. We're not like when you go out and you buy stock where we get to vote on any kind of changes in the management or the upper echelon. We don't get proxies. We're not even getting dividends should the corporation do well or anything like that. So we are in nowhere near like a security. We have actually purchased a commodity, just like if we bought a barrel of oil from Exxon. They'd say, hey, take your barrel and go. Thank you very much. We're not getting, stocks in Exxon because we bought a product that they produced. That is not the case by far. Now, I want to take a look at this article right here because I think it is actually more legally defined than the previous article, but it really speaks to this issue. As the conclusion of the widely publicized lawsuit between the United States Securities and Exchange Commission and Ripple Labs looks to be drawing near, one particular leading expert, and we're talking about John Deaton, had a few things to add in favor of the blockchain company. Specifically, the defense lawyer and popular commentator on the case, John E. Deaton, said that the SEC was overstretching its arguments, drawing attention to the Howey analysis the regulator used to assert that XRP token was a security, as he explained in a Twitter thread on January the 16th. He specified that the SEC's argument in which it claims that XRP token is a security at all times was in itself evidence that the use of the Howey test in the Ripple Labs case at XRP was problematic and difficult thing to even carry out. Because guys, what happened back there in that Howey case was that he had actually sold some contracts, investment contracts to individuals with respect to various plots in his orange groves. Now, the oranges themselves were never designated as securities. What was a security was the investment contract, and you and I never entered into an investment contract with Ripple as purchasers of XRP. There is no commitment on Ripple's part to absolutely do anything to help to result in a benefit for us being holders of XRP. None whatsoever, which was a completely different issue back there in that Howey test. Now, he's saying here, Deaton highlighted the 3,000 affidavits showing that first-time XRP buyers weren't even aware of Ripple. And I remember that, guys, when I got into this space, the exchange that I was actually getting on only held three assets. They held Bitcoin, they held Ethereum, and they held XRP. Now, I knew about Bitcoin, and I kind of knew a little bit about Ethereum, but I absolutely knew nothing about XRP when I was first purchasing it. And by the way, guys, back then I was getting it at like 10 cents on the very, very low back in that March, April of 2020. But I'm telling you, right now, I did not even know Ripple existed until much, much later when I really started to investigate this space. So I could have been one of these guys that filed an affidavit and said that they purchased it for non-investment reasons, receiving benefits from XRP completely independent of Ripple, and the fact that the SEC's expert witness backtracked on arguing Ripple was a common enterprise. That is a major, major deal. Now, down here, Deaton's view, all of this proves that the SEC is in the wrong and that XRP satisfied both the second and third prongs of Howey and that its chances at winning the case are slim. On top of that, the attorney posted a section of his submitted argument that said, in his view, that's not how a Howey analysis works. And it certainly doesn't make a token itself always a security, no matter the circumstances. People predicting the SEC will definitely win and that XRP is doomed are overstating the SEC's chances. The SEC's allegations are stretching too far. Guys, the reality is this. We are dealing with a situation where you've got Ethereum that absolutely had an initial coin offering, or we're literally telling people, hey, if you get in low here, you're going to do really well because. Well, that never happened in Ripple's situation. In fact, majority of the cash that they initially raised was through venture capital investment. And XRP was in existence before Ripple was. And XRP was gifted to Ripple. Now, Ripple turned around, opened up a subsidiary where they could actually sell that gifted asset. So just imagine now that, somehow you got a gift from Tesla and they decided that, hey, you're going to be the lucky millionth customer and they're going to give you one of their roadsters. And you turned around and then you sold that asset. Oh, okay. You think the SEC is going to come along and say, oh, hey, you got that gift of that Tesla, but you didn't register that with us and you went and turned around and you sold it. Well, you'd say, yeah, but I just sold an asset. Exactly, guys. That's all Ripple did. Would there be any investment contract in the rest of any business dealings you did to the person who purchased your Tesla? Absolutely no way. It's a ridiculous argument. And that is the same deal. Ripple was gifted XRP, and it was one of their assets that, yes, through a subsidiary, they did sell. But guys, it was not in order to raise money like Ethereum did with initial coin offering in order to establish their business so that they could go out and do what they're doing. They did it with venture capital money. And by the way, when they did go out and they actually made some amazing business contracts and deals, they went back to those original angels investors and they paid them back. And guys, they got a valuation of over $15 billion for doing it. And that's the difference here. There was no investment contract, no relationship between you and I as holders and Ripple as the corporation. If you want to have a stake in Ripple, hey, you got to go out there right now and buy private equity and be an accredited investor to do that. An accredited investor is someone that is worth $1 million liquid over and above their principal residence. And guys, none of us that had not went out and bought the private equity but bought XRP were buying any kind of an investment contract or security. And this whole common enterprise idea falls to pieces once that's taken away. Now, interestingly enough, in the arguments that are being put forth right now by the SEC, you know the language that they're using? There's a common interest. Well, a common interest is way different, guys, than a common enterprise. Let's be honest. Hey, there's lots of people that have an interest in gold. You got jewelers, you got bullion dealers, guys, you got computer manufacturers, you got all people around the world that have a common interest in gold. But there's no common enterprise there. That would be like taking the entire global gold market and saying that everybody who purchases gold for any reason is purchasing a security, and anybody that sells gold for any reason needs to register with the SEC. It's absolutely ridiculous because the reality is, guys, we are purchasing a commodity. It's a digital commodity, yes, but it functions and works in this digital asset space kind of like what gold would. Why? Because people use it for all kinds of various different applications. Ripple's using it as a bridge asset. They're using it in their on-demand liquidity platform for cross-border payments. Heck, some people right here in the United States are using XRP to pay their employees their wages. It is not a security. At best, it is a currency and a type of a commodity. Because why? It has all the handmarks of a monetary instrument, right? It's a store of value. It has a unit of exchange. There's 1 million drops for every XRP. And it is a medium of exchange. It's a unit of account and a medium of exchange. Sorry about that. Where you can use it to purchase things like goods and services. Well, hey, look at gold. Gold as a commodity. Is it a store of value? Well, yeah, we know that. It's been money for over 5,000 years. Is there a unit of account for gold? Well, sure. We measure it in weight by ounces and sub-ounces and stuff like that, right? And is it a medium of exchange? Well, of course it is. People have been trading gold for other goods and services for thousands of years. Well, just because XRP is the new kid on the block, it has all those monetary attributes. It's not an investment contract. Just like an ounce of gold or a bar of gold is not an investment contract. It is a commodity, and like I say, or a monetary instrument at best. So guys, I think it's going to be very, very interesting to see how everything pans out and what the final decision will be on this case. Now, I do believe that, hey, those Hinman emails are going to play a big role in whether or not we actually see the judge order that the SEC has to make those available to the public or not. And I think if Judge Torres does that, then more than likely we'll see a settlement before we see summary judgment. However, if she doesn't do that, then maybe we'll see a summary judgment and then a potential settlement. Now, I want to show you something else that is really quite interesting, considering we're talking about this whole case and how it will impact the future for these digital assets going forward, and more than likely for decades. Just take a look at this article here. The fight to regulate crypto at crossroads as the Ripple ruling looms. Guys, this decision is going to have massive, massive lasting impacts. Just take a listen to this. In the wake of the implosion of cryptocurrency exchange FTX, one urgent question keeps resurfacing. Who should regulate the industry? An upcoming ruling in New York federal court could help determine the answer, along with the fates of numerous crypto investors and companies. The case hinges on whether a prominent digital token should be treated as a security, which would fall under the Securities and Exchange Commission's jurisdiction. The dispute dates back to 2020 when the SEC accused San Francisco-based Ripple Labs of selling unregistered digital tokens without adequate disclosure. SEC Chairman Gary Gensler has been working to position his agency as the force that would rein in the crypto industry. And should the regulator prevail, it would strengthen its grip at a crucial moment. A decision could come in the first half of 2023, and most of us are expecting some kind of a decision before the end of March of this year. Among a handful of closely watched fintech lawsuits, the Ripple decision is the most high profile. Its digital token XRP is the sixth largest crypto token with a market value of almost $20 billion, according to CoinMarketCap. The recent turmoil in crypto markets could taint the court's view, said Joseph Hall, a partner at Davis Polk and Wardwell, who worked at the SEC from 2003 to 2005. You just have to imagine that the judges will be influenced by the investor losses they've seen, Hall said, and the SEC will make clear to them that if you rule the other way, we will not have the tools we need to fight this kind of activity. What a bunch of disingenuous hogwash. Literally, they want the courts to rule, even though it's not even legally, like we talked about, a security, does not meet one prong of the Howey test. We just want our judgment so that we can put the pressure on and we can be the enforcers. And if you don't judge our way, we won't be able to spank these guys with the law. It is absolutely ridiculous. FTX's bankruptcy in November left customers and investors facing billions of dollars of potential losses. And several of the company's executives have been charged with various types of financial fraud. Before his arrest, FTX founder Sam Bankman-Fried was a prominent voice in the policy and debate about regulation. What's really amazing in all this is these guys have the gall to come out and say this kind of stuff when Gary Gensler was literally having meeting after meeting after meeting with SBF himself. And the SEC has an investigation division that they should have known that there was something seriously wrong and going on with FTX. Just think of this. If FTX goes out and issues an FTT token, don't you think, guys, that that would be on the radar and that would have been, hey, looked at as a security by the SEC? Nope, they just turned a blind eye to that one and they go right against Ripple, who, by the way, have been working with the SEC and regulators in the United States for years and years and years, and voluntarily coming in and working with them. It is truly amazing the gall that actually the SEC and Gary Gensler are trying to put out here. So listen to this. Gary Gensler, he formed close ties with U.S. legislators, SBF, and advocates for a bill to give the Commodity Futures and Trading Commission oversight over certain tokens. But remember, SBF was wanting other tokens to be governed by the SEC, a move some saw as an attempt to wrest jurisdiction away from the SEC. And that is absolutely not what was going on. The fallout from FTX's implosion was swift and devastating, pounding an industry that had already had a rough year. Token prices plummeted, deepening a rout that began last April. Several crypto firms filed for bankruptcy, and high-profile backers of FTX were forced to write investments down to zero. Guys, it was a fraud. This has nothing to do with the legitimacy of digital assets. This has to do with an exchange that literally was playing around with investors' money, their actual clients, $8 billion of it, and trying to Ponzi it around so that they could actually make it work for them, and they lost out. It was an absolute classic fraud. It had nothing to do with the illegitimacy of digital assets. Absolutely nothing. That is baloney. The potential contagion effects of crypto collapses are now more apparent, said Howard Fisher, a partner at Moses and Singer and former senior trial counsel at the SEC. The FTX disaster will be more of a touchstone in inspiring government regulation. Now, guys, having said that, I think we need regulation, but we need honest regulation. We need transparent regulation. We need fair regulation, and we need regulation that involves people in the industry helping to craft it, and not those ones over at Consensus that have been in the back back pockets of the SEC the whole time, and you know who I'm talking about. And we need to actually have people on the ground that legitimately know this space, are looking for a level playing field, and that works for everybody. For an asset to be classed as a security, it must meet a legal standard from a 1946 U.S. Supreme Court ruling about the sale of tracts of Florida citrus groves to investors. The test is met if investors kick in money with the expectation of profiting from the efforts of an organization's leadership. It is an investment contract, and there is no investment contract. Ripple has contended that XRP doesn't meet that test because sales took place in the secondary market and there were no pooling of profits. That's a fact. We aren't getting some kind of a dividend because Ripple is now worth $15 billion valuation, that's for sure. Selling an asset on a secondary market is most akin to a commodity, like I was explaining earlier, and should be regulated as such. The company's general counsel, Stuart Alderati, said in an interview, "You don't lose customer protection and keep bad actors out. Regulation needs to be done in a way that respects the reality of what an asset is." An SEC spokesperson, they declined to comment on the Ripple suit. Amazing. Why? Because they have all their lackeys over here that will make comments for them. That's a big reason why right there. Trading in digital asset commodities, which U.S. regulators have largely agreed includes Bitcoin, is subject to a patchwork of state regulation, but not federal oversight. Some policymakers have sought to rectify that through legislation to give the CFTC authority over those types of tokens. But if the Ripple ruling determines that XRP is security, it would give the SEC ammunition to claim jurisdiction over the majority of digital assets, says Carol Goforth, a professor at the University of Arkansas School of Law who specializes in fintech regulation. Guys, the reality is this case, the decision of this case is really going to be telltale when it comes to how this whole space is going to unfold. And I'm telling you, in my view, there is no way that you can apply a 1946 ruling over something that was an absolute investment contract over the tracts of land, and the oranges themselves were not the securities. Otherwise, every grocery store in America would have had to register with the SEC to sell oranges, right? Because those would have been securities. It had nothing to do with the oranges. It had to do with the investment contract in a common enterprise, and we never got that. You could have gone out and bought bags and bags of oranges, and they wouldn't have been securities, just like we're going out and buying bags and bags of XRP. Our XRP that we're buying is not a security, and we need to get our voices out there and advocate with our legislators, with our members of Congress and folks like that, hey, look, this is what we see it as. This is where we're looking at the future. This is where we need you guys to step up and really learn about this space, not just get influenced by all these lobbyists over there that want to seem to give a free pass to Bitcoin and Ethereum and axe out everybody else. No, we need a level playing field, one that's fair and one that's transparent, and we need to get out there in force and literally be writing and phoning in to our members of Congress, our senators, and letting them know, hey, this is what we think. This is what we're coming at. And hey, look, our opinion does matter. Remember this, guys. You don't have to be an absolute expert. You just have to be a voter. We put these guys in office to represent us. And that's what it comes down to. And these guys that are out there, Congress needs to come out and provide absolute clarity and not just leave it to the third branch of government and to the legal court system where there's absolutely no elected official in that capacity making a decision like that. We have to get out there and get our elected officials to absolutely do their jobs and get these permanent bureaucrats like Gary Gensler literally out of there, and where they're accountable to Congress and not just, sidestepping every issue. And my guess is this, guys, when they try to haul this guy before Congress to face the music, he's out of there. He's going to leave Tucktail and run so fast. He's going to retire. He is not going to face the music. That is at least what I believe. Now, guys, having said that, I think that we are in for such an amazing ride in 2023. I truly think it's going to be fantastic. And look, there are a lot of guys out there like John Deaton, like Fred Rispoli, you know, all these other lawyers, Jeremy Hogan out there, all these other guys are looking at this case and they're like, hey, look, you cannot adjudicate this case in the way in which the SEC is trying to push it and absolutely come out and say, look, there's fairness and transparency in the judicial system. And most of these guys are saying that Ripple has a really good chance of coming out on top here, and absolutely XRP could get the legal clarity it's looking for and be the only digital asset with that legal clarity. So I am really excited to see what happens next. So guys, let me take a moment to talk about our coaching program. Now, as you know, as this space starts heating up and we are getting closer and closer to moving up in this next bull run, you're going to want to have your plan in place. And what our coaching is, that's where you and I actually meet personally one-on-one for 1 hour over Zoom. And during that time, we actually take a look at your exit strategy and we apply some very specific techniques that will help you to actually execute that strategy when it comes time. Now, we also help you with your portfolio and taking a look at how you've got it established and what your goals are for that portfolio. Now, something else that we do, and of course, this is not all that we do, but if you're also needing us to help you get your assets off an exchange and onto a hardware wallet, we can do that along with the prior things that we mentioned. Plus, on top of that, we go over some really amazing techniques that are genuinely going to help you out in this space. Now, the cost for that is $250. Now, if that's something that interests you, you write me right there at coaching@thedigitaloutlook.com and we'll get you all booked in. So guys, I really hope that you enjoyed today's video, but I want to also invite you to join that conversation and drop your comments right down there in the comment section and open it up to the rest of the community and start a discussion. Now, many of you know that I'm not a financial advisor and that this is not financial advice, but if you found value in it, if you'd hit that like and subscribe, I'd appreciate it. And hey, don't forget to hit that notification bell down there so that you don't miss out on any of the videos that we're uploading. And if you're one of the thousands of people who have been watching these videos but you haven't yet subscribed, would you do the channel a favor and join this community? We would really love to have you on board. So in the meantime and in between time, stay safe, be blessed, and I'll catch you in the next one.